have clicked the go live button. We are live. And with that, all right. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. Joining me on the panel this morning is Justice James Milkey and Justice Dalila Wendland. We will be the panel for all 6 cases that we'll be arguing this morning. And we will take a break after the 3rd case. We have the first 3 cases are criminal cases. We will resume after a 15-minute break with the remaining 3 civil matters. We will also suspend briefly the YouTube live stream in between each argument to admit the attorneys for the next case from the waiting room and to do a quick sound check before we resume the argument session. Otherwise, the parameters are identical to those in a live argument in court. 15 minutes to a side, no rebuttal. With that, we will call the first case, Commonwealth versus Sorensen.
Good morning, Chief Justice, members of the panel. May it please the court. Sarah LaRoche for Eric Sorensen. Since Ford was decided in 1975, it has been the law in this Commonwealth that police may not go to a home without a warrant to arrest someone. Since that time, other cases such as Marquez, Street, and Molina have taught us that the conduct by police in this case, the very conduct, was improper and led to an invalid arrest. And that is going to an apartment building, going into that apartment building, going up to a defendant's door, knocking on the door, and arresting him. Now, to the extent that the court does not agree with Mr. Sorensen's analysis of Marquez, Street, and Molina, that is that this space where Mr. Sorensen was arrested just over the threshold of his apartment was protected by the 4th Amendment in Article 14. It matters not because application of the done factors also leads to the inescapable conclusion that that space where he stood qualifies as curtilage of his apartment.
Counsel, can I ask you a question?
Of course.
In Molina, where was the defendant when arrested? Or can you, I don't know that case, so can you just give me briefly?
Sure, Your Honor. In Molina, which is a case that's actually quite factually similar in many ways to this case. In Molina, the defendant was inside the apartment. And the officer, I believe, was also inside the apartment.
So be precise, were they inside the apartment at the time of the arrest?
Yes, I believe so.
Okay, and then in Street, were they inside the apartment at the time of the arrest?
In Street, the officers were in the common hallway of the apartment building.
Where was the arrest effected in Street?
Street is not clear about whether, I mean, we know that the officer knocks on the door. We know from the case that the officers are standing in the hallway when the arrest is effected. We don't know, frankly, whether the defendant is inside of his apartment, on the threshold of his apartment, or outside of his apartment. The case does not tell us that fact.
Okay, and then in Marquez, was the defendant inside the apartment on the threshold or outside?
The defendant was inside, and the police officer, same police officer as in this case, Murray, was inside.
As I understand your argument, you are essentially treating the common hallway outside of the apartment as being the functional equivalent of being part of the apartment itself. the legal term, as you've alluded to, is curtilage.
That's correct, Your Honor. But in my argument, I don't make this as clearly as I could have in my briefs. My argument about Marquez Street and Molina is that even though they don't say curtilage, because those cases don't use that term, effectively what those cases say is that space where a person is arrested around their home is protected by the Fourth Amendment and Article 14. And
let's move outside of the apartment context just for a moment so I can understand what it is you're saying when you say around their home. Suppose a defendant in a single family dwelling is on the public sidewalk in front of their home. Are they protected or not?
That's not curtilage of their home.
Okay, so now we're back to the use of the term curtilage. And that, I think I'm more comfortable operating within a precisely defined legal term than around their home. So if we're talking about curtilage, if he's standing on the front porch of a single family home, that's commonly recognized as curtilage.
The classic exemplar of curtilage.
Because that's part of his property.
Because that is a space, I believe Leslie talks about the space of the front porch being a place where guests are welcomed to the home. Leslie is very clear, that's the 2000, that we can't apportion these rights and the status of curtilage based on whether a person has a single family home or an apartment. And in the same way,
that, but the foundational linchpin is an expectation of privacy in their home, the right to be secure in their home. And I understand the case law to draw a distinction between the apartment unit itself and a common shared corridor over which the apartment exerts no exclusive control.
In Leslie, we're talking about a second floor apartment. The front porch and the yard, which are not exclusive to that second floor tenant, are curtilage of that second floor apartment.
In a two-family dwelling.
Yes, that's correct.
Okay, but if we're talking about an apartment a multi-unit apartment building that has, let's say, 20 units, 4 floors and 5 units on a floor, the common hallway is not a part of any of those units, nor is it a part of the curtilage of any of those units, correct?
But that's correct. But that space where Mr. Sorensen stood, it is intimately tied to his apartment. He cannot use his apartment without.
What is the evidence that it is intimately tied to his apartment?
Because he can't use his apartment without it. In the same way that guests are welcome to the home in Leslie on the front porch, Mr. Sorensen's wife welcomed Officer Murray to their apartment in that very space.
One may not access a home at the end of a cul-de-sac without going down that dead-end street.
I'm not talking about the hallway. I'm talking about the space that is immediately outside of his door.
I'm having a little trouble at an intellectual level understanding the distinction you're drawing between the hallway and the space outside of his apartment door. I thought the space outside of his apartment door was part of the hallway.
It is part of the hallway.
Okay. So what you're saying is that a part of the hallway that is close to his apartment is should be treated as part of his apartment and not part of the hallway.
Yes, and again, I don't want to get completely hung up on the notion of curtilage, because I think if you look at, there's a quote in the Molina case. So again, Molina is not talking curtilage. And Molina says, there was no justification for the officers to go to the defendant's apartment with the purpose of arresting him without a warrant. That's what Marquez stands for, that's what Street stands for, and that's what Molina stands for. They say officers cannot go to the home or to the apartment. Those three cases are about apartments. They cannot go to the apartment without a warrant. And it doesn't matter where the players are standing.
So,
Yeah.
to be clear, let's say the officers are standing on the public sidewalk outside of the apartment building, and they call to the defendant through an open window and say, come down here, we need to speak with you. And he comes down to the sidewalk and they arrest him.
If it is an area immediately outside of his door, I believe that is different from being called down to the sidewalk.
Well, but the point is that they went to the location for the purpose of arresting him without a warrant. And I understand that you are saying that it's different, but I'm looking for
under the cases, I believe that would be an invalid arrest. Molina goes on to say that the officers cannot, in the situation, as the Commonwealth argues in its brief, oh, Mr. Sorensen should have just closed the door. Molina says the officers can't then try to justify that arrest by saying there was an exigency. That was an exigency in Molina that was created by the officers.
But the difference was that he was inside of his home, not outside of his home.
But in the first place, Molina says very clearly, it is improper for police to go to arrest in the apartment without a warrant. And it's not about where people are standing, because this is black letter constitutional law, and it cannot rise and fall with where the players are standing. This is a space that is so tied to his home that when he stands there and he is arrested without a warrant, that is an unlawful arrest.
Even if you're correct that the arrest itself was unlawful, does suppression have to follow where there was apparently probable cause to arrest?
In Molina, there was probable cause to arrest. The evidence that was acquired at the time of the defendant's unlawful arrest were statements by the defendant and observations within the apartment, and they were suppressed. So the answer to your question is yes.
But weren't the statements here made outside the threshold of the apartment?
The arrest was unlawful. The statements were made at the very time that he was arrested. Because the arrest was unlawful, those statements would be suppressible, should have been suppressed.
Let me, maybe I missed this in the argument, but how this is, of course, post-appeal.
That's correct, Your Honor.
So the claim here is that he's entitled to a new trial because of the failure to seek suppression of those statements based on the invalid arrest.
That's right, Your Honor. It's an ineffective assistance of counsel.
Right. Help me understand the relationship between those statements and the evidence that led to the conviction.
The conviction rested on essentially three things. The first category is the statement that the defendant made, which was inculpatory. He said, I was home on Saturday night, before he was told that he was being arrested for something that happened on Saturday night. He also had a cut on his finger, and both the statement and the cut on the finger were highlighted in closing argument. When a person is involved in a stabbing, sometimes they cut themselves, and the statement was also highlighted in closing. The other two categories of evidence that led to his conviction were testimony by the victim, and the victim clearly lied on the stand when he said he was going to meet his friend to sell her telephones when everybody else testified that it was a drug deal. And in his own words, in his own testimony, his ID of the defendant was not an identification of the defendant. So his testimony was not rock solid testimony that Mr. Sorensen was the perpetrator. Yes.
I'm not overwhelmed by the materiality of the statement that I was home on Saturday night, and the cut on his finger. I'm sure contribute to some degree, but we're talking about a substantial risk here, right?
That's correct, Your Honor. Basically, my point is the victim was completely not credible. He didn't ID the defendant, and the other witness had ample reason. She also, I think, demonstrably lied during her testimony.
So the jury concluded otherwise, and I have I guess a little bit of difficulty believing that it was because of the inculpatory statement made outside in the hallway.
The Commonwealth highlighted it in closing. The Commonwealth, the whole Saturday statement led to sort of a mini trial about the reasons why the defendant might have said that to the police. It took up 3 pages of the closing argument of trial counsel. So I do believe that these 2 pieces of evidence were inculpatory. I believe they were focused on, and the other 2 witnesses that the Commonwealth relied on were not believable and would not have been believed but for the evidence from his arrest.
Okay, thank you very much.
Thank you.
For the Commonwealth. You need to take yourself off mute. There we are.
Good morning, Kevin Curtin, Assistant District Attorney on behalf of the Commonwealth. So defense attorney filed this motion on August 1st, 2013. That was 4 months after the United States Supreme Court decided Jardines. And just 11 months before that motion was filed, the Supreme Judicial Court reiterated that with respect specifically to multi-unit apartment buildings, as opposed to single family or multifamily houses, like as was later considered 4 years later in Leslie, but that with respect to multi-unit apartment buildings, the concept of curtilage is applied narrowly, and that was the state of the law. In 2008, in Marquez, the court stated that the Fourth Amendment and Article 14 have drawn a firm line at the entrance to the house, and that absent exigent circumstances, that threshold may not reasonably be crossed without a warrant. Going the other way, in 2012, just some months before this motion was filed, the court repeated in Escalera that curtilage in an apartment building is very limited, and quoted a 1971 case that a tenant's dwelling cannot reasonably be said to extend beyond his own apartment and perhaps any separate areas subject to his exclusive control. So in 2013, no reasonable lawyer could have seen that there was anything for the defendant to pursue in a motion to suppress focused on the question of curtilage. Now, I'm aware, as is the court, that 4 years after Attorney Callahan filed this motion in Leslie, the SJC applied this doctrine to multifamily houses in a case where there was a fenced side yard, and expressed as a 2-family or 3-family house that affording different levels of protection to different kinds of residences is troubling because it would apportion Fourth Amendment protection on a ground that correlates with income, race, and ethnicity. So what Leslie was expressing concern about a legal approach that in the absence of any efforts to obscure, this is the fourth done factor, an individual cannot express a cognizable subjective expectation of privacy in that which they make accessible to the public, that can be seen by the public. So and I can see how the court could be concerned about that, and that application of the done factors could, if it was mechanically or thoughtlessly applied, could create inequities. But the court reiterated 4 years later that these factors are only a help in answering that key question, which is whether the area in question harbors those intimate activities that are associated with domestic life and the privacies of the home. Leslie was still able to apply the Dunn factors, and Leslie wouldn't have helped the defendant in this case. In 2013, the law was very clear, and I think it still is quite clear. You know, the front porch is the prime example of a space that is curtilage. A car parked in a parking lot is not.
Can I just stop you for a second and ask you about the front porch issue?
Yes. Yes, Your
There
Honor.
doesn't seem to be much of an expectation of privacy in a front porch, even in a single family home, where everyone from the mailman to solicitors have an implied license to come on the property and knock on the door. Doesn't an apartment dweller have more of an expectation of privacy in a common hallway interior hidden from the public than, say, a single family homeowner with regard to a front porch?
I think that they're sort of analogous. In Pietras, the SJC dealt with the type of a porch that you would have to walk through in order to get anywhere. So someone walking through a front porch to knock on the door, or a mailman walking through a front porch to put mail into a mail slot, that is privileged, as the proper analysis would be, that there's a privilege to being there, but it's a limited privilege. So for instance, a Girl Scout can go and, they walk into a porch and knock on the door, but can't stay there forever. And so the analysis, and so an interior hallway is kind of similar to that type of a porch. And there's never been a case that has held that in an apartment building, a multi-unit apartment building, the exterior hallway, which is common to others, is an area in which an individual has an expectation of privacy. So,
two tests here, though. I thought the curtilage test was really about property rights, whereas the reasonable expectation of privacy was a separate test under the Katz doctrine.
That's correct.
Are you agreeing that they're conflated, or are they two separate things?
No, they're not conflated, and they are two separate things. And
right, so under the curtilage analysis, we're guided by the Dunn factors.
Correct.
But for the reasonable expectation of privacy doctrine, what governs our analysis in terms of the common hallway?
Well, the question would
be the fact that it sounds like you're conceding, even though the record does not suggest that this was an interior hallway to the building.
Well, it was an interior hallway to the apartment building.
Okay,
that's what happened.
It's enclosed by the building. It's not like a porch where you could just walk on. Why is there a reasonable expectation of privacy in that enclosed space?
Because that is a space that is as to which people have a privilege to be present. They have a right to be present.
A license, a limited
police
license.
officer has the same right to be present, regardless of any subjective expectation or a subjective thought of the police officer. And that's how I would analyze that, Your Honor.
And what legal authority are you relying on for that? That a limited license to enter the common hallway defeats a reasonable expectation of privacy?
Well, in Jardines, that would be the analysis that Justice Kagan would have applied. So the question in Jardines, so you asked about whether property measures are the sole property rights of the sole measure.
Is Kagan's the controlling decision?
No, Justice Kagan wrote a concurrence.
Right.
Sticking with
Scalia, how do you?
Yes.
How do you deal
with
Justice
Scalia didn't, Justice Scalia analyzed it in terms of property rights. Okay, but even Justice Scalia said in his main opinion that property rights are not the sole measure of Fourth Amendment violations. We have cats. So if there is no physical intrusion, that's where we start with physical intrusion and curtilage in the house under the Fourth Amendment. that if there was any physical intrusion upon the curtilage, then you don't need to establish an expectation of privacy, because curtilage are these areas that harbor those intimate activities of domestic life and the privacies of the home. And it's a clear line that police and everybody knows that the penalty for an unlawful arrest in the defendant's dwelling is the suppression of anything seized at the time of the arrest, either from the defendant or in the dwelling, and any statements made at the time of the arrest.
Let's just say we agree with you that this is not curtilage.
Yes.
My question is on the reasonable expectation of privacy.
Right.
Why does this get affirmed even under that analysis?
Because this is not such as Justice Kagan posited in the concurrence in Jardine, which is why I'm calling your attention to that. In that case, the use of a trained dog on the porch was intended, and this is something like counsel for the defendant is trying to suggest by saying that police may not go to a home for the purpose of making an arrest without a warrant. Justice Kagan would have held in Jardine that the Fourth Amendment violation was the use of a trained dog on the porch to reveal evidence within the confines of the home that police could not otherwise have found. It's like the Kylo case, the enhanced technology to see or perceive something inside of the house. That's what the dog brought to the table. In Leslie later on, police did the same kind of thing. They just wandered away from the front door where they could ask questions just as anybody else, and started looking around and looked into an area where there was that was curtilage. And so it's not as if curtilage is the only touchstone for Fourth Amendment violations. It's not. For instance, there might be a tree house that is not part of the curtilage. I think of a curtilage, and I'm trying to think of what could be curtilage in smaller homes. Well, it might be like an herb garden just outside that serves the home. Herbs for the kitchen, that sort of thing. Maybe it is kept separately. I've seen areas and hallways where people have put things outside of their apartment, but that doesn't make it the home itself. That does not make it necessarily part of the home, but you can find out by applying the Dunn factors. So, I think that the expectation of privacy goes side by side, is certainly something to be considered, even in a case like this now. And the way that it would be considered would be to determine whether this was a search of an area that would not otherwise be permissible. So, and I have not found a case, by the way, in Massachusetts where a defendant was improperly arrested in a location that wasn't in his house, but still within the curtilage, without a search being conducted. So we have, approached, in the context of searches, this issue a little differently from the context of arrests. It's a bright line, police in the house making an arrest. That is the bright line. And there's no question that the arrest in Marquez occurred in the house. And
can I stop you there?
Yes.
So are you saying that police can arrest someone, say, on the front porch of a single family home, even though that's curtilage?
I'm not saying that. I would say that if they don't have a warrant and someone is on the front porch of their house and they're speaking to the person steps out of the house, they're on their front porch within the curtilage of the house, absence exigency, I say no. I would say no. Unless there's exigency, you'd have to go and get a warrant.
So
now, how would that apply in a case in an apartment building? I think that is the law. If police come to your house and they don't have and you stay in your house, or you close the door, or don't even answer the door. By the way, you have a right not to answer the door. It's not cited in the briefs, but there is a case, Kentucky versus King, a 2010 Supreme Court case. You don't have to answer your door. In the same way, if the officer says, would you please come out into the hallway? You don't have to do that either.
Okay, but if the person is on the porch when the police come, so they're not drawing him out of the house, Could they arrest him without a warrant?
I would say no, absent exigency. I would say that if someone is in their home, or which is the equivalent within the curtilage of their home, the police cannot make an arrest within the home without a warrant, absent exigency.
About 2 minutes ago, you suggested that there's a different analysis for arrests than for searches. And now you seem to be saying it's the same geographical scope.
Yeah, I mean, the courts have treated them a little bit differently. It's true, but that doesn't mean that they don't equally apply to protect Fourth Amendment rights. You know, the right to be free from being arrested by a police officer in your home without a warrant is established under this curtilage doctrine. Other things that the police can do snooping around your house without a warrant are established by tons of other law having to do with, you know, expectation of privacy. But this is a limited protection. It's very clear. Everybody understands it. Everybody. And that's why
What
it needs to
if,
be
in
a
Judge
right one.
Milkey's analogy, the police officers found the defendant on the front porch, and the police officers were on the sidewalk and said, "Hey, can we talk to you coming down to the sidewalk?" Is that seems to be closer to what happened here? Would that be a suppressible motion to suppress? Why not?
Because it doesn't matter, because it's the location. It is the location when it comes to a warrantless arrest, whether it's in the home or outside the home. On the sidewalk, it's clearly going to be outside the home. On the porch, maybe it is, maybe it isn't. You know, depending on the done factors, depending on the use. That's the most important thing in the done factors. You know, this fourth factor, we're concerned about it, and maybe in some case there might be an opportunity to say something more about that. But they've never been applied unfairly. Thank you.
Time has come to an end unless there are further questions from the panel. Seeing none, the case is submitted. We will resume with the next case on the list. Let's see if we can.
Pressed the stop button, but it still says recording. Nope. Give me a second. Okay, I think we are not streaming to YouTube anymore.
Patricia, you're muted. Patricia, you're muted if you're trying to say something.
Press the more button.
More button
on your Zoom screen.
Okay.
And stop live. Stop YouTube.
We resume our session with case number 2019 P584, the Commonwealth versus Rafael J. Torres III. Counsel, you may begin.
Good morning, Your Honor. Kathleen Kelly for the appellant Rafael Torres. Our first argument on appeal is the ineffective assistance of counsel argument for trial counsel's use of the outstanding warrants on cross-examination, and also in his closing argument to show Mr. Torres's reason for flight from police. Trial counsel himself elicited this evidence on cross-examination of a police witness, and then used it again in oral argument or closing argument, excuse me. The warrant evidence was strong propensity evidence and showed Mr. Torres has a propensity to commit crime and was highly prejudicial to his case, especially where it was used by defense counsel himself.
Now, you acknowledge in your brief, as you must, that this was a strategic choice by defense counsel. That being the case, don't you have to show that that choice was manifestly unreasonable at the time it was made?
Yes, and I believe that's our argument, that it was manifestly unreasonable. There was really no need to bring in that evidence because it doesn't negate any state of mind with regard to the crime itself.
Well, the fact that your client led the police on a high-speed chase is pretty strong evidence of consciousness of guilt, isn't it?
Our argument is that trial counsel would have been better off relying on the Commonwealth to prove its burden, or coming up with some other reason why, other than the fact that he had outstanding warrants.
Such as, I mean, the case against the defendant was pretty strong. And I suppose that's another hurdle in terms of the showing that you have to make here. You have to establish that better work by counsel would accomplish something material for the defense. And in the overall scheme of things, the case against the defendant was shall we say, pretty strong. So what is it that counsel could have done alternatively, other than to provide an alternative innocuous reason for the defendant to have sped away from police, rather than his guilt, his awareness that he was being chased for the carjacking?
Well, he could have, for example, he could have argued, it appears there was a third person, perhaps in the Jeep. He could have argued that because there was no identification of Mr. Torres, that wasn't him that actually participated, and that perhaps he wasn't aware of everything that went on with the.
Well, I assume that's what what counsel was trying to accomplish by saying that he was not aware why they would be chasing him, having to do with the Infinity. He thought they were chasing him because of the warrants. But once you're tagged for leading them on a wild chase, that blows a pretty sizable hole in the suggestion that he didn't know why they were after the passenger.
Well, he also could have argued that the co-defendant, sorry, my audio is off a little bit. He could have argued that the reason why the co-defendant left the vehicle, perhaps he didn't know that the co-defendant had a weapon, or there's other arguments he could have made rather than just introducing evidence that he had outstanding warrants.
And
that was manifestly unreasonable. That was manifestly unreasonable, even though it was coupled with the limiting instruction by the judge, which was given twice.
Well, it's noteworthy that the defense counsel didn't request a limiting instruction. It was the trial judge himself that gave the limiting instruction, and it was defense counsel who introduced highly prejudicial testimony that Mr. Torres had outstanding warrants.
Don't we assume that the jury followed the judge's instructions, whoever requested them?
Well, I think you still have to look at the prejudice to Mr. Torres, especially where defense counsel is the one eliciting this testimony. That's our argument, that it's still highly prejudicial to Mr. Torres.
How does the one-inch differential really make for an improper closing argument?
Pardon me?
There, you claim that the closing argument was improper because I think the prosecutor said he was about 5'3" and he was actually 5'4".
Oh, yes.
He's a victim.
Yes.
Yes. So on the second argument, our argument is just that the prosecutor was appealing to the sympathy of the jury rather than focusing on the actual testimony. If there's no other questions, I don't have anything else to add to the brief. I'd be content to just rest on the brief.
Seeing none, we will hear from the Commonwealth.
Thank you.
Morning, may it please the court, Kristen Jing for the Commonwealth. On the first issue, as my brief lays out, our position as defense counsel was not ineffective for presenting evidence of the defendant's prior outstanding warrants. Under Safarian and under Watson, as I cited in my brief, the defendant would have to show that defense counsel's decision was manifestly unreasonable when made. In this case, as was just elicited, there was very strong evidence of guilt, and there was strong evidence that the defendant in this case fled from police through a snowstorm. At one point, there were 10 different vehicles following him on 93. The only reason he was stopped was because his vehicle became disabled. So defense counsel in this case was trying to explain away that, other than the fact that he participated in this crime. Just because the defendant was eventually found guilty does not mean that this decision was manifestly unreasonable. It was a strategic decision that didn't work out in this case. And I cite a number of cases, including Moore and Durakowski, where counsel made a similar strategic decision, admit to another type of bad act, in order to pursue a strategy that the defendant did not commit the worst act or the worst crime. In addition, the trial judge also gave limiting instructions saying that the jury was to consider the defendant's prior warnings, if they even found evidence of that to be credible, as evidence of the state of mind and not for any other purpose, including bad character or propensity.
Counsel, just a factual question. What is the state of the record with regard to the length of time between the taking of the car and the initiation of the car chase? Because it seems a little uncertain.
Sure. The best I could find in the record was that the victim said just a few minutes after the people who perpetrated the crime had left, he called the police. And then there was testimony from Officer Bussey, I believe was the first officer that located the car. He said he saw the car pass him just a few minutes after getting the radio dispatch. So you can kind of infer from that it was just a few minutes after the crime had occurred that Officer Bussey saw the Infiniti vehicle pass him. And if there's no further questions on this issue, I can move on to the second issue. Our position is that the prosecutor's summation was proper, and regardless, there was no substantial risk of miscarriage of justice in this case. As to the 1-inch differential in his height, wasn't a misstatement. Even if it was such a minor comment. And the jury had the ability to view, what the defendant looked like, how tall he was in person. And then as to,
right, not the defendant.
I'm sorry, Your Honor.
The victim, right, not the defendant.
Oh, I'm sorry. Yes, the victim. They had the opportunity to see how tall the victim was in person. And then as to the second argument, the prosecutor may suggest what conclusions that she wants the jury to draw from the evidence. And there was a very strong evidence of consciousness of guilt, which could go to guilt on the charges that were brought before the defendant. So if there are no further questions, I will rest on my brief.
Seeing none, the case is submitted. We will bid you farewell and move to the next case on our hearing list. Okay, the next case, we resume our argument session this morning with the civil portion of the hearing list, beginning with case number 2019 P931, Sarah A. Tanner and another versus Phyllis Sherwood. Counsel, you may proceed.
Thank you, Your Honor. Sarah Coles for Sarah A. Tanner and Terry Tanner, individually and as next friends of Shauna Tanner. May it please the court. Your Honors, this case involves a horrific car accident which led to permanent and lasting injuries for a mother and her 11-year-old daughter. The car at fault in this accident was driven by Phyllis Sherwood, the defendant in this matter. It is undisputed that Ms. Sherwood was suffering from an undiagnosed brain tumor at the time. But this case is about so much more than a simple medical emergency defense. This case is about the existence of of a disputed issue of material fact that goes to the very central issue of this matter, which is foreseeability. This case goes to whether or not the witnesses are credible in this matter. And that credibility issue presents itself in twofold, not only for one of the witnesses in this matter, but also for expert testimony in this matter, whereas one of the experts in this matter disregarded material facts that were presented. And all of those factors together, Your Honors, together make it an error for the Superior Court to have allowed the defendant's motion for summary judgment based on a sudden medical emergency defense. And I ask you at the end of this argument that we overturn the decision and remand this case back to the Superior Court. Your Honors, on April 8th, 2017, the car driven by Sarah Tanner, which her 11-year-old daughter, Shauna Tanner, was riding in, was struck from behind by the vehicle operated by Phyllis Sherwood. And Ms. Sherwood's vehicle was going at 90 miles per hour. The Tanner's vehicle flipped over, and both Sarah and Shauna have suffered from lasting and likely permanent injuries as a result of this accident.
Attorney Cole, we are familiar with the factual background. As I understand it, the crux of your argument is that there was an inference that a reasonable trier of fact could draw from the fact that the car started and then resumed operation, that the operator of the vehicle had the capacity to consciously operate the vehicle without any other evidence bearing on the nature of that stop and start.
That's correct, Your Honor. There was an eyewitness to this case. There was an individual named Jessica Larson who was driving behind the Sherwood vehicle. And Ms. Larson tried to corral the Sherwood vehicle to the side of the road and then witnessed the Sherwood vehicle stop for 10 to 20 seconds on the side of the road, which gave Ms. Larson enough time to take off her seatbelt and go to try to render aid. And what's very important during those 10 to 20 seconds, and those 10 to 20 seconds mean everything for this case, is that the passenger in the front seat, Ms. Hop, she has stated that she did not stop that vehicle, which leads to the inference that Ms. Sherwood had the ability to control her vehicle at some point during those 10 to 20 seconds when it was stopped on the side of the road. And that, Your Honors, presents the exception to the sudden medical emergency defense that's presented in Ellensgaard versus Silver, which
I'm familiar with the limitations of the doctrine. I guess I'm trying to understand the basis for the factual inference that you're pressing. What is it about the fact that the vehicle stopped and then started again that supports the inference that it was a conscious act that led to that during the midst of a seizure?
Because, Your Honors, Ms. Hop, who is in the front seat of the car, has stated that she's not the one who stopped the car.
Actually, didn't she state that the car did not stop?
She has, but Your Honor, taking the evidence in the light most favorable to the plaintiff in this matter, Ms. Larson, who was following behind, said that car stopped for 10 to 20 seconds on the side.
Right, but what we know is that the car stopped. We don't know why. What you're suggesting is that it is a fair inference that it stopped and resumed operation as an act of conscious volition by the operator. As I understand it, the alternative is that we have really nothing to go on other than speculation as to why it stopped and started in the midst of a seizure.
And Your Honors, I'd suggest to you that presents a jury question. It's a question of fact, a jury question that should go before the impartial fact finders in this matter. And that's why this matter was inappropriately resolved on summary.
Why is it a question of fact if there is no factual support for the actual cause of the vehicle's observed operation?
Because I feel that we do have some facts here. We have an eyewitness who said the vehicle stopped, and then we have Ms. Hop who said that she did not stop the car.
No, but let's accept favorably to the plaintiff that the vehicle stopped. Okay. What your argument is not made simply by the fact that it stopped and then resumed. Your argument must be that the fact that it stopped or the fact that it resumed its forward progress resulted from an act of conscious volition and not incidental to the effects of the seizure. Where is the evidence to support that assessment?
Again, it comes from the fact that Ms. Hopp said that she didn't stop the car. And also, Your Honors, right after the car stopped and started again, it was able to actually drive and navigate a bend in the road. It didn't just proceed in a straight manner. It did turn a corner, which suggests some sort of control over the vehicle prior to the car stopping, and then some control after the car started again.
Or can I just say, to put it differently, I think what I hear you arguing is that it is impossible to navigate a turn on Route 6 accelerating to 90 miles per hour unless you had some conscious control.
And that's true, Your Honor. I'm not sure how familiar you are with Route 6, but it can get very bendy in that area of Route 6 itself. So it does suggest the absence of Ms. Hopp saying that she stopped the car does suggest that there is some degree of control of the vehicle, which is key here, Your Honors. That 10 to 20 seconds where that car stopped on the side of the road opens up that window to what was going on, and there's a question of fact. There is a question of fact that should be presented to a jury that allows the jury to determine whether or not she had the ability to control her vehicle at that time within the Ellen Scard exception.
So you're not relying on the expert for that evidentiary basis to conclude that Sherwood had the ability to control in light of the 10 to 20 second stop.
Well, we do have.
You're relying instead on a reasonable, I guess you would call it, inference.
I'm sorry, Your Honor. I actually cut you off briefly and I didn't understand your question.
You're not relying on your expert for the proposition that she regained consciousness and was able to control her car.
Our expert has given an opinion, which I understand is disputed, that the fact that the vehicle did stop and start again would allow for some degree of control over the vehicle. And I would suggest, Your Honors, that actually leads me to a point of credibility issue that we have also discussed in this matter. The fact that the defendant...
Wait. On summary judgment, we view all credibility in your client's favor. So I don't see how that's an issue, right? The car stopped for 10 to 20 seconds and was able to maneuver a bend in the road. So given that, you're saying that that a reasonable jury could conclude that Sherwood regained consciousness.
A reasonable jury could conclude that she had some degree of control over her vehicle at that time, since the car did stop for 10 to 20 seconds. And we have an impartial third party who said that that car stopped. And so because of that, Your Honors, because the car stopped on the side of the road for that 10 to 20 seconds, that key 10 to 20 seconds, I suggest to you that this really is a question of fact for the jury and not something that should have been determined.
Can I interrupt you?
Yes.
How is this distinguishable then from the McGovern case?
In the McGovern case,
right. In that case, the defendant, there was a fellow traveler on the road who heard the defendant honk his horn just prior to the accident. And there was evidence that the defendant lost consciousness at some point. The SJC nonetheless said the fact that he honked his horn was not a reasonable basis for rejecting the conclusion or the doctrine of sudden medical emergency. How is this case different?
Your Honor, in this case, again, like this isn't so much as a horn honk, which could have just been someone falling onto the steering wheel. In this case, we have a conscious stop, a stop of the car.
Which would have required falling onto the brake pedal instead of the steering wheel. Is that the distinction you're drawing?
For 10 to 20 seconds, I would suggest to you, Your Honors, that it wouldn't be falling onto a brake pedal rather than a steering wheel. I would suggest that it does take a controlled ability to control the vehicle to stop a car for 10 to 20 seconds. So it's not just a mere just something that happened, happenstance of the circumstances. It's something that she had to have some degree of control in order to make that decision to do so. And Your Honor, it's just because of that, because of those 10 to 20 seconds, this case really needs to go. The jury very might well decide that the sudden medical emergency still controls in this matter, but that's a jury distinction in this case. We have that we have those issues of foreseeability in this case, where there was this 10 to 20 second window where there was possibly.
Can I stop you again? Why is that an issue of foreseeability?
Because the foreseeability exception in Ellensgaard, Your Honors, allows for when there's warning symptoms of physical failure during operation. So if the car stopped for those 10 to 20 seconds, that was a warning sign of possible further issues with operating the vehicle. There is another warning sign, Your Honor, too. And
Okay, let's stick with that one. You're saying the car stop was a warning sign
well,
that she would
if she was
collide?
able to stop the vehicle for those 10 to 20 seconds, then there is some warning of something that might have been amiss before and is amiss now, a degree of something that she should have heeded to at that time.
I thought your argument was that she was suddenly able to control the car.
So she's able to control, if it took off again afterwards, I'm saying, if she was able to control the car, she should have heeded to that warning. Something was wrong.
Okay. I thought your foreseeability argument was the headache 2 days before.
That is also part of the foreseeability issue. And I would like to just draw your attention to the fact that the expert has opined that foreseeability does arise for a brain tumor of this magnitude and even the slightest of symptoms. And whereas a headache might not be something that is a warning symptom for you or I, for example, Ms. Sherwood did testify that she'd only suffered from 2 to 3 headaches in her entire life, which is a feat in and of itself and something that I frankly am a little jealous of. But I would.
The argument is that she should have gone for diagnosis on each of those prior occasions.
Oh, I'm sorry, Your Honor. My argument would be that she might have noticed that something was wrong since she didn't really, this is out of the ordinary for her. This isn't something that normally occurred. So she should have maybe taken a step back.
So were each of the previous 2 occasions?
Well, I don't, fortunately,
Right.
Your Honor, I don't know when those other 2 occasions were.
No, neither do I. But the point is that that to suggest that because she infrequently suffers from headache, that she should believe that the onset of a headache is suggestive of something quite dire. I'm not sure I can follow you all the way there.
What I would suggest, Your Honor, is just based on the fact that she didn't have consistent medical attention over the years. She has stated that the last time that she had a physical was in the 1980s, but that coupled with the fact that something out of the ordinary for her happened might have suggested to her that maybe she should have consulted a doctor at that time.
And I assume then that your expert opined that had she gone to a doctor 2 days prior, she would have gotten the MRI to diagnose the brain tumor?
No, the expert is not opined that, but the expert has said that maybe this was a warning symptom because symptoms do present in even the most fleeting of manners. So,
But okay, let's say that it was a warning sign of something, and she had taken the action that you think she should have taken, going to the doctor. What would have been the results, the diagnostic result of going to that doctor?
we don't know, Your Honor, it could have been nothing.
Except by speculation, but I think that there is nothing in the evidence to suggest, as Judge Wendland has described, that she would have gotten an MRI that would have identified the presence of a brain tumor.
That is correct, but at least then, Your Honor, we wouldn't be sitting here and saying that there is a question of fact for the jury regarding whether or not she could have had some kind of foreseeability going on.
Well, one of us wouldn't be asking that question. I'm not sure all of us are asking that question.
Your Honor, just briefly, just because I see I have 5 seconds left, I just do suggest that this is the reasons that negligence matters are not typically decided on summary judgment. So I would ask that based on these material fact issues that we have discussed today, that this case, the decision of the Superior Court be overturned and brought back to the Superior Court.
Thank you. Attorney
Chief, if I could ask one question of
Of
counsel.
course.
Page 29 of your brief is missing, at least in my version. If I could have somebody get me that page, I would appreciate it, or get us the page.
Okay. I don't, how's the best way for me to do that? I'm sorry, Your Honor.
I think the what I would suggest is that you you can submit that through the e-filing portal.
I will have that taken care of as soon as we're done, Your Honor.
Thank you.
I apologize. Mine is complete. So.
Thank you. Attorney Kelly.
Thank you, Your Honor. Good morning. May it please the court. My name is Maria Elise Kelly, and I represent the defendant, Phyllis Sherwood, who is the appellee in this particular matter. I, of course, am asking that this court uphold the summary judgment decision that was entered in the lower court. And the basis for that is that it is our position that there are no material facts in dispute about whether there was a sudden medical emergency. That fact is agreed to by both the experts, the plaintiff and the defendant. There is no reasonable inference that can be drawn that Ms. Sherwood voluntarily stopped her vehicle and then voluntarily elected to proceed forward.
Counsel, can
Yes,
I cut to the chase? It's not hard to imagine someone involuntarily stopping a vehicle. Just your foot, one way or another, has to come off the accelerator. Not a big deal. It's a little harder on the navigating the curve. Is it possible to navigate a curve, possibly at very high speed, without some conscious control?
I think it is, Your Honor, and I would respectfully suggest to you that what your question goes to is exactly what should not happen here. We should not allow the jury to be guessing with respect to that. There is evidence, for example, that the passenger, Ms. Hoff, grabbed at the wheel at different points in time. Whether that caused the movement of the vehicle or its ability to go around the corner, we just don't know.
But isn't that a fact? Isn't that a fact question?
Well, it's not a material fact question, Your Honor, because the issue at hand is not whether the forward movement of this vehicle was a function of whether the Ms. Sherwood was the agent of the forward movement of the vehicle. I think there's no question that you could draw a reasonable inference that her foot hit the pedal and caused this vehicle to accelerate to 90 miles an hour. What you can't draw the reasonable inference is that that was a conscious movement and decision as opposed to a feature of the seizure that she was having in place.
Why not? Counsel, can I ask, why not? Why isn't that a reasonable inference? Either it was the seizure, or it was Ms. Hoff, or it was the driver who was conscious.
Well, Your Honor, because you're asking the jury to guess on the basis of an absence of evidence. And there are several sources of potential evidence in this case. One could be the expert witnesses, neither of whom can tell you why the pedal was depressed after the stop. No expert has told you that it is the natural sequence of this type of medical condition where you would lose consciousness, then regain consciousness and regain the ability to formulate a rational decision. There's an absence of evidence of that, and that is a medical question which we should not allow a lay jury to speculate about. I'd also suggest to you that there is lay witness evidence here that is supportive of the notion that Ms. Sherwood never regained consciousness. And there are three sources. One is Ms. Hoff in the vehicle, who's very clear that the driver never regained consciousness. There's also the testimony of the EMTs who came to the scene and observed that Ms. Sherwood at their first response was still in what they referred to as a post-ictal state, with her eyes transfixed forward and non-responsive. So I think that it strains credulity, and it goes to the reasonable inference to suggest that she suddenly lost consciousness. She regained consciousness. She elected to disregard her current medical status. She then lost consciousness again before the EMTs came. It simply is a flight of fantasy that we really should not ask the jury.
But counsel, for present purposes, we have to assume as true that the car was able to navigate a curve after the seizure happened. And why isn't it a reasonable inference that, barring evidence that the passenger, in fact, was controlling the steering wheel at that point, that the driver had some control?
Your Honor, I would suggest to you that it's not a reasonable inference because it requires a speculation. All we know is, taking the facts in the light most favorable to the opposing party, that the vehicle did accelerate, that it did go around a curve, and that it did reach high speeds. There's no evidence to support the notion that those were conscious decisions on the part of the operator, as opposed to involuntary movements, for example, during the course of the seizure, or Ms. Hoff grabbing from the passenger seat. It ultimately would require the jury to simply speculate about what they thought happened here. And I suggest to you that it's both a factual and a medical question, and there is an absence of adequate evidence to allow the jury to make that decision. This is not a case where we have competing expert opinions on the question of, did Ms. Sherwood have the conscious ability to drive after the stop? If you carefully read the report of Dr. Copa, he does not say that it's his opinion to a reasonable degree of medical certainty that the defendant regained consciousness. In fact, he states just the opposite. He states that there are questions to, and he doesn't opine the answer to the question. So I would respectfully suggest to you, if the medical expert is incapable of determining whether this was a voluntary decision by the driver to accelerate, or whether it was part of the natural sequence of the seizure, then certainly a jury is not in a position to decide that, and it would run afoul of the well-established case law requiring on an expert issue there to be an expert opinion, and requiring there to be a factual basis from which to draw a reasonable inference. And I would suggest to you that before you, there is simply inadequate evidence of that. Moving to another issue, if I may, there's been a suggestion about Ms. Sherwood's, what I'll refer to as failure to have adequate medical care. And that is not a basis of liability as reflected in the prior case law. So I would suggest to you that that appears, at least on my review, to break new ground. But even if you were to find that the failure to have adequate medical care over time is a basis for liability, there's a causation problem in this case. And what I mean by that is no medical expert has told you that had Ms. Sherwood sought immediate medical attention after that last headache, or at any point in time, that she would have undergone adequate diagnostics to discover the meningioma that was growing. And so again, this goes back to the absence of a medical opinion, the fact that we can't let a jury speculate about what diagnostic tests would or would not have uncovered. The record is just barren with regard to that particular issue in terms of what, if anything, testing would have revealed, and whether there would have even been any testing. There's no evidence before you about what the standard of care is relative to an individual reporting an isolated transient headache that was resolved within 24 hours. And quite frankly, I think that it's highly speculative that an MRI would have been ordered under that scenario. And there's certainly no evidence from the experts who would have been able to tell you, had it been the case, that the standard of care would be in reporting a single transient resolved headache to order an MRI. So we just don't have that piece. There's no evidence that Ms. Sherwood ignored warnings. There's no evidence that Ms. Sherwood knew that there was a fairly immediate likelihood of an attack that would render her incapable of operating the motor vehicle at any time, either before the vehicle stopped or after the vehicle accelerated forward. And I would respectfully suggest to you that given all the facts in the light most favorable to the plaintiff, no question, very serious injuries, serious accident, but the issues here are much less severe in terms of what prior case law from this court and the SJC has required and still found a sudden medical emergency. And just to touch briefly on that Ellingsgard case, you know that it was an issue of an individual driving a boat who had a very long and complex cardiac history. He was on medication for those conditions. There were certain neurological symptomatology that boat driver was experiencing ahead of time. And notwithstanding that, the court upheld the notion that the fact that he lost control of the boat was a sudden medical emergency because he had no knowledge that on that day and time, there was nothing to put him on notice that he would lose capacity to safely operate that vehicle. That is a much more robust set of facts, which shows an extreme end of this. And here we have a much more, I would suggest to you, a much smaller series of facts from which you cannot leap to the inference that this individual, because she had a headache 3 days earlier.
You know, in light of your distinguishment of the Ellingsgard case, can you distinguish the Booley case, the Carroll versus Booley case? In that case, the defendant hit the plaintiff with his car. Prior to the incident, he was not visible in the that he was found by EMTs having suffered a coronary attack.
Your Honor, in that case, I would
say that that one goes to the jury.
Yes, and the reason most respectfully that I would suggest to you that the SJC let that one go is that there was undisputed evidence that the driver had run the red light prior to the medical event. And as I understood the facts of that case,
he had run the red light and suffered a medical event. It's not clear the timing of either in the SJC. That said, that presents a jury question.
And because in that case, the running of the red light was some indicia of negligence that occurred before the medical event, as I understand it, the court said that the whether the heart attack was before or after the accident did not alter the outcome, because there was evidence that he had run through the red light. I'm not sure that I'm responding 100% to your question, but I thought that the timing of it was that it was unclear whether the medical event had any bearing on the fact that he rode through the red light. Whereas here, there's no question that there's a prior medical event and then the accident. And so this is really more along the lines of the McGovern versus Tillinghoff case, where there is no history and there is a sudden event and then the accident. And so, again, I would suggest we're more in line with the McGovern case in terms of the factual comparisons. And having said that, I see that we only have a few seconds left. So unless there are further questions, I will respectfully stand on the written materials and ask this court to uphold the summary judgment decision. Thank you.
I think the chief may be frozen.
Thank you, counsel. The case is.
My name is Yang Li.
Wait. Our next case on the list for hearing is case number 2019 P 1546 Yang Li versus Zhang Yanling. Okay, you may begin.
Thank you, Your Honor. Statement of issues. Whether the Superior Court erred in allowing defendant's motion for judgment on the pleadings. Whether the court erred in ruling that the defamatory statement, "Those sex gossip about you have nothing to do with me," is a protected use of imaginative expression. See Milkovic 497 U.S. at 20, see Code 386, Mass 312. Statement of case. The appellee defendant Yan Lin Zhen is a real estate agent. She visited the appellant plaintiff Yang Li's home once to evaluate the value. Plaintiff did not hire defendant to sell the house. Defendant posted a series of statements to Chinese WeChat group of 437 members. Defendant posted, "Those sex gossip about you have nothing to do with me." She commented, "The rumors spread in whole village and history online in such." Defendant's statements directly caused the plaintiff to be removed from a civil rights group on the next day. Plaintiff filed this defamation complaint to Middlesex Superior Court on December 21st, 2018. Defendant then posted a public threat to get fire to burn your body to a WeChat group of 219 members. The case never went to discovery. Plaintiff's motion to amend the complaint was denied. Defendant's motion for judgment on the pleadings was allowed. Superior Court adopted English interpretation sex gossip as the same meaning from the original Chinese word, fei pink.
Excuse me if I can interrupt, Ms. Lee.
Sure.
Okay, the parties are agreed for purposes of this motion that the translation of pink news is sex gossip or rumors. What does that mean in terms of, one can imagine the whole spectrum of statements that could fall within that rubric?
Okay. Pink news, you know English word, black mail, yellow page, white wash, or blacksmith. It's just a normal word, but I translated to be pink news. Fei Wen consisted of two Chinese individual words together called pink news, but in Chinese, the definition translated through Google translation. Okay, let me read the definition to you. The old refers to peach-colored news. Star celebrities have more negative reviews, usually referring to the erotic stories between a star in the film and entertainment industry and the surrounding heterosexual or homosexual. Generally speaking, when a scandal occurs, the male and female protagonists of the scandal will have new works, such as a new song releases, and generally use the scandal to hype.
So you know, so are you saying that if I suggested that someone was gay, that would be pink news?
No, if you say someone has a sex scandal or sleep with someone or something bad things, that's called pink news, erotic story.
Okay, but if I said that, you know, Bob wife cheated on him, would that be pink news?
That's typical pink news.
Okay, and if I said that Bob cheated on his wife, that would be pink news.
Pink news, yeah.
And if I said that Bob hadn't had sex with his wife for 10 years, would that be pink news?
No, no. If anyone's regularly like divorced or remarried, that's not pink news. That's normal life. Pink news is bad.
Well, how, understanding that you think it means something bad, there seems to be a lack of specificity in terms of this. And a defamatory statement has to convey a verifiable statement of fact. And I'm trying to understand what verifiable statement of fact we're talking about here.
Okay. The pink news, if I have a normal life, that's not pink news. Okay. If something, for example, if in English, if you said that man and harassed his female employee, that's negative. But if he never harassed his employee, that's defamation. Correct? Okay, and it's 9 minutes. Let me finish my statement of fact. Is it correct? Because otherwise the time's over. So, sorry.
Go ahead.
Hello?
Please proceed.
Yeah. Okay. And okay, the judge ruled statements that implies the existence of pink news are also, in this court's view, a protected use of imaginative expression, so the case was dismissed. Statement of fact. Plaintiff is a former senior software engineer who had worked in Raytheon for years. She moved to Sudbury, Massachusetts 20 years ago. Defendant is a real estate agent who moved to Sudbury 5 years ago. In 2016, plaintiff planned to sell her house. She asked the defendant to her home. Other than that meeting, actually only 10 minutes meeting, plaintiff and the defendants never met each other again. At that meeting, after that meeting, plaintiff felt something was wrong. Some Chinese in the local Sudbury WeChat group started to be rude to plaintiff for no reason. Plaintiff did not know who those people were because they used the WeChat ID. Plaintiff suspected that the defendant might say something behind her. Since that time, defendant was the only one who knew plaintiff's real name behind the WeChat ID.
Ms. Lee, if I could stop you there again.
Yeah, sure.
If you and everyone else were using pseudonyms, how would anyone know that any statements that Ms. Zhang made about you or made about your pseudonym were in fact about you? Because
well, WeChat group just like similar to the Zoom, except we don't have a video show face, but we text. You understand? We text. So one guy texted with his WeChat ID, and with WeChat tool became popular just that year, 2016. So I did not use my real name. I used my WeChat ID called Zebra, Z-E-B-R. But because the defendant came to my house, so she knew who I am. Judge, Your Honor, if you don't put your names there, and if you don't show your face there, only with your ID, I know someone, this guy always talk, but I don't know his personal life or who he is.
I think Judge Milkey's question was a little different. Because I had the same question.
Sure.
So if maybe the defendant knew who you were by your screen name, but if none of the other members of the WeChat group knew, was able to connect the screen name to you personally, how does the statement about your screen name have anything to do with you in the eyes of all of the other WeChat members?
Because she's talking about the issue, the things defendant used her real name and her name, picture, and real estate ID. So defendant WeChat ID actually is her business ID. She just used my personal story to help her real business, her real estate business. So, and all her texted I snapshot. I saw she in some WeChat group, she publicly commented, she's delusional, like Zyber's delusional. The delusional, this is my story because I had a litigation against my ex-employer Raytheon many years ago. That time, defendant was still in China, and she's not even immigrated into US. In that case, and Raytheon hired a psychiatrist, labeled plaintiff to be delusional. So whenever she say me delusional, which means she mentioned that. If that case, if race discrimination case could cause my local Chinese people rude to me, that would be many years ago. But the rude situation only occurred after she visited my house and only occurred for the recent 2 years. And the rude situation continued for 2 years until December 11, 2018. And when plaintiff chatting in a group with 437 members, defendant suddenly joined the conversation. That made plaintiff alert. So plaintiff posted, I have lived in Boston for many years. This is the first time.
Ms. Lee, if we could cut to the chase, how were you damaged by this? You, in your complaint, you say you're seeking $1 million in damages. Speaking only for myself, I'm having a hard time seeing how, even if you won everything at trial, you'd be entitled to anything more than nominal damages.
But what about the public apology? Because she posted sex gossip and never apologized. That ruined my reputation. And the 437 Chinese, they are US-wide spread. They don't know me very much. So if she posted, oh, that woman has a sexual scandal, and the people would take the defamatory as true. So, and she posted a bunch of statements, but for the very bad word is a sex scandal. And also she said that, and she continued to post it. Can you allow me to post your real name and let everyone see your history online? There were rumors spreading among the village, but I'm not involved in your business. I don't know why you are so hostile to me. I was forced to say these words tonight. Even if someone asked me about you, I would never talk about someone like you. She said if someone asked her, that means someone asked her privately.
Okay, but her comment about the pink news was in direct response to your saying that she had no character. How does your statement that she had no character, doesn't that presuppose that she's done some bad things?
She has no character is almost all the Sudbury people knew, because anyone asked her look for a house or buy a house, eventually did not hire her. She would be very angry to the person, whoever never asked her to sell the house. She could spread the rumors. It happened for another woman in Sudbury. Her name is Miss Chin. And also she hired people to cook dinner for her children. But she refused to pay another Chinese lady's labor fee. And she claimed that because you eat the dinner with my children, that's why she stopped to pay her. And also she sent the children to a daycare, another Chinese opened the daycare service. And based on the contract, if the children missed one day, she still need to pay them because that lady keep the one position for her kid and she never paid. So that lady continued after 2 years closed her service because defendant started this style caused all the kids' parents stopped to pay that daycare service if their kids missed 1 day. So and that daycare service continued for more than 10 years. It's just because she breached the contract, and so they closed in 10 years. So her story is lost in Sudbury, but the trouble is this case never went to discovery, and I never have a chance.
Now, do you understand, Ms. Lee, that were you to prevail in this case, in the case to go back in discovery, the other side presumably gets to ask you about your sex life? And
yes, sure. Sex life, no, the pink news should be cheating. If divorce, married, that's it's a public issue. It's not a pink news. Pink news is based on cheating.
All right. I see that your time has expired. We will hear from counsel for the defendants. And we do have the arguments that you've made in your written brief, which we will also consider as part of the review of this case.
Thank you, Your Honor.
Thank you. For the defendants?
Yes, good morning, Your Honors. May it please the court. My name is Michelle Blair and I represent Yangling Zhang in this matter. And she is asking that this court affirm the decision of the Superior Court wherein judgment was entered on the pleadings on her behalf on the single count of plaintiff's complaint. There are 3 grounds, Your Honor, that I would submit this court in a de novo review can affirm that judgment. One is the statements themselves are not defamatory, that they fall into the category of rhetoric, hyperbole, imaginative expression, or opinion. Specifically,
can I just stop you on that?
Of course, Your Honor.
The argument about the pink news is that there's a specific statement that there is a rumor out there about pink news. That, at least on its surface, appears to be a statement of fact. There is a rumor out there about this subject. How is that either excusable hyperbole or an opinion?
I would ask the court to look at it in the context it was made. The case law definitely talks about not taking phrases or words in isolation when you're considering whether something was defamatory. And if you look at complaint paragraph 7, which is at RA Record Appendix 6-7, that statement comes within a line of comments that are made by my client, which starts out with her defending herself, where she says, "Are you attacking my character? I believe that everyone who knows me knows what my character is." Then she says, "Those kind of pink news about you have nothing to do with me. Please pay attention to yourself. You can take whatever medicine you want, but you can't say whatever you want." This was something that was said in reaction to my client being verbally accosted or in writing accosted when she was in this chat room. So I think when you take it in that context, that's where the Superior Court decided that that was kind of an imaginative or creative way to say, basically, mind your own business. So I would ask the court that in taking that in the context in which it was stated, that it does not rise to the level of a defamatory statement of fact. Does that answer your question?
It responds to my question.
Your Honor, I would suggest also that the second statement that is.
If I can just stop you for a moment, we appear to have lost the Chief Justice.
Oh my goodness, then I shall definitely wait.
If we can just tread water for 60 seconds.
My client starts out with, first of all, defending herself. I have this is the 9th paragraph of the complaint at Record Appendix page 007. And she says, "I have a wide variety of activities and a lot of contacts with people. This is the first time I have heard that my character is no good, but I will not cater to people at trash level. I believe that the people in the group look at your endless arguments. It is easy to guess that you have delusional symptoms. I also saw the opinions of the group of friends and found that their words are similar. It seems that the whole village has very consistent opinions about the rumor regarding you, and it is not good to switch black and white. So the pink news and rumor don't actually appear in the exact same sentence. With regard to delusional symptoms, I would say that the word delusional falls into the line of cases that say that if you describe somebody as ill or sick, or do you have bipolar disorder, says that those are not defamatory statements. And those are mentioned in the case of Brosnahan versus City of Somerville. It's a 128 summary decision.
Counsel, can I ask you a question?
Of course.
Why are you making a distinction between the post that says pink news and this one that says rumors, when I thought it was your position, at least for purposes of the pleading, that pink news is sex gossip?
Well, we had to concede that for the purposes of the motion and the standard that the court was going to apply, which is to take the allegation in the light most favorable to the plaintiff. So the court applied that, her interpretation, plaintiff's interpretation to that. So that is the position I was taking for the point of that argument. I'm making a distinction here because I'm trying to show that we're taking phrases from different parts of posts, but they're sandwiched in between. My client really just trying to say, I stop attacking my character, mind your own business, which is what the court took from it in terms of reading it as a whole or looking at it as a whole, that the statements that the plaintiff is highlighting are really sandwiched in between statements that my client was just making to defend herself, saying, I have a good character, a lot of people know me. And I think that those words have to be reviewed in that light. The court in other cases, such as the Kelleher case, I have the site, excuse me. I shouldn't just refer to it by its first name. Kelleher versus Lowell General Hospital, which was decided just in July of this year, where they did look at the frustration of the employer in that case, saying in that situation where the employer was frustrated and he said, you never help and I'm done with her, that you have to look at the context in which the statement is made. And so I'm asking this court to look at the context in which this statement was made, which my client goes into a chat room, is almost immediately accosted. There's just handles in there and she responds to the handle, not necessarily a person's name, but the handle of the person who's accosting her. So I think that needs to be taken into account, as well as the audience itself, which is, again, as the court has already pointed out, you pretty much have anonymous people in there who are using handles. And the appellant has even admitted in her argument that she did not use her real name in this chat room. So any statements that—
Isn't it possible to defame a pseudonym? I mean, if you, for example, think of the artist known as Banksy, for example, I would think it might be possible to defame Banksy, even though no one has any idea who he is.
I think the facts here are different, Your Honor. Just again, in the appellant's argument that she made a short time ago, she said she did not use her real name because she had concerns about people talking about her in Sudbury. So I don't think, I think it's possible, but I don't think that's been pled here. I don't think it's been pled with any sufficiency that somehow the use of the name Zeber, it's not even referenced in the complaint at all, is somehow directly attributable to Ms. Lee, and how that would be directly attributable to Ms. Lee. There are no facts to support that. So
but we're at the pleading stage.
Correct.
So I think you're arguing summary judgment stage. At the pleading stage, is it plausible that she has stated a claim?
No, I don't think she has. I don't think.
Well, I know that's your position, but the argument that it's not her, it's her handle, that it's not associated, those are factual things that get discovered, not at the pleading stage.
I think she needs to make the allegation as to how she was defamed, and that's not even covered in the complaint. It's not even, she doesn't even acknowledge handle versus person. So I think there's got to be enough facts.
Let me back up on two fronts. First of all, I believe even within the bare allegations of the pleading, there is the suggestion that somehow the comments made about her screen name were attached to her personally by members of the Sudbury community because she began to experience rude treatment in response to that comment in the chat room, and suggests that the two are causally related. Separately from that, it seems to me that one could believe that spreading false sexual innuendo about an individual portrays them in an adverse light. Isn't that fair?
Well, on the first point, I would like to address each, Your Honor. On the first point, I don't believe the facts are that she received rude treatment after the comments in the chat room. I believe the comments that the way that this has been pled is that for 2 years she had been experiencing rude treatment, and then when she saw my client come into the chat room, that's when she made those statements to her because she had been receiving the rude treatment. The rude treatment did not come after the comments in the chat room. That's my understanding, Your Honor. So I think the facts there don't support that. But in terms of spreading false sexual innuendo, if I suppose it could be, but again, I would ask the court to take the statement in the context it was made. It's not, she didn't just come out there and talk about pink news or make false sexual accusations against Ms. Lee. She started out by saying, "Are you attacking my character?" She was defending.
I understand that, but you're not allowed to use libel or defamation in self-defense.
But all she said was those kind of pink news about you have nothing to do with me. So there's nothing to say that she created the rumors or spread the rumors. She's just saying it has nothing to do with me.
If the rumors, if it was false that there were such rumors,
right,
isn't that defamatory?
If it was,
couldn't that be defamatory?
If someone is spreading false rumors, could that be?
No. If no one was spreading false rumors, but the defendant said that they were.
That is the existence of sexual rumors.
I guess it would be, but I don't think that's what was said here in the state. Again, I asked you to look at the statement in the context. It says those kind of pink news have nothing to do with me. Please pay attention to yourself.
And part of what that statement connotes is there is a rumor out there about you that it constitutes sex gossip, whatever that is.
Well, it's very speculative, Your Honor, to say if there was a rumor and then she's not spreading a rumor, she's defending herself in a chat room and saying, if there are rumors about you, they have nothing to do with me.
Suppose she is in defense of what she perceives as an attack on her character. Suppose she falsely says, hey, there's all this rumor about your sexual activity, clean up your own house, don't come after me. And if the statement that there is all this sex gossip out there about you, if that statement is false, that she's just making it up, is that not actionable?
I don't think in this context it is, because there are other issues as well to be considered in the claims that are made.
Well, let's view it just for the moment, if you'll humor me, just in isolation. If stating that there is a gossip and a rumor that portrays the target in an adverse light, if stating that there is that gossip and rumor is stating something that is not factually true, and it is designed to portray the target in an adverse light, the mere statement that those rumors are out there, why would that not be actionable?
In the context of this case, it's because of the way that the statement was made in terms of the full statement that was made. So I would say the facts in this case, it's not that she just came in to a chat room and said, hey, I've heard all these pink news gossip about you. She didn't come in there to attack or to level anything. And I think that the manner in which it's portrayed, and it is portrayed in the translation most favorable to the plaintiff, to come into a chat room and say those kind of pink news about you have nothing to do with me, I do not believe rises to the level of defamation. I would argue it does not.
As a matter of law.
Yes, as a matter of law.
And what is your best legal authority for that proposition?
the best legal authority is that is looking at the standard and the analysis that
I'm looking for a case.
Well, the case, I don't have a case that specifically says that that statement is not defamatory, Your Honor. What I can look at is the analysis that the court is supposed to go through and the judicial experience and common sense that should be applied to seeing whether or not there's enough heft to this statement for it to be defamatory. That when you're walking into a chat room and you say a statement, those kind of pink news about you have nothing to do with me, that does not rise to the level of defamatory statement.
Okay, let's just assume for the sake of argument that the statement could be considered a defamatory one. Since it was in writing, wouldn't this constitute a libel? And if so, wouldn't she be entitled at least to nominal damages?
I think that there has to be some proof of economic or some sort of harm here, Your Honor. The only harm that has been alleged is that a while later, she was removed from a chat room. She said in her argument today that the next day she was removed from a civil rights group. That is not an allegation in the complaint. That allegation is made for the first time as we're sitting here.
Isn't it suggested by the allegations in the complaint where she says immediately after talking about the incident, and then I was removed from the chat room?
No, she said a while later I was removed from the chat room. She didn't say immediately thereafter. She said a while later I was moved from the chat room.
And then she says that after that, she approached your client about settlement, and that was 3 days after the initial incident.
I didn't believe she said it was 3 days after the initial incident, Your Honor. I may have missed that.
Well, she says that in the amended complaint. Don't we have to the extent the amended complaint goes beyond the allegations of the initial complaint, given that the judge ruled based on futility, don't we have to assume the truth of any factual allegations in the amended complaint?
No, because it's not a part of the record below us. It wasn't a part of the record before the Superior Court. It's not a part of the record before this court right now. It wasn't allowed to be amended. That issue was not preserved for appeal, and that was entirely within the discretion of the court. So I do not believe the court should consider the allegations in the amended complaint. It's a non-entity. It doesn't exist.
Okay, one last thing from me, and this is more of a comment than a question. When I asked Ms. Lee how she incurred anything beyond nominal damages, the response that I heard, at least, was that what she's really interested in is an apology that the statement about pink news is not true. I just mentioned this in case after we're done today, the parties were to see it in their interest to resolve this case themselves. We will obviously do our job in resolving the legal issues put before us.
Thank you, Your Honor. Thank you, Your Honors.
Chief, you're muted.
Thank you both. That concludes the argument in this case, and we will return, and you may begin after we call the case. Okay. Our final case on the list for hearing this morning is case number 2019 P598, Anthony Vignani versus Mass Medical Services, Inc. and others. You may begin.
And it's Attorney Goulet, Your Honor, for the appellant.
I'm sorry, for the appellant. Yes.
Michael DeLeo from Attorney Goulet from Crowley and McCarthy. This case is, I won't go through the background as you just suggested, but the case is a case that I think can be cleaned up by the Brzezinski case. I say cleaned up because the Brzezinski case, we led with that in our brief because that potentially solves some a messy situation here. And why do I say that? Because the Brzezinski case is very factually similar to this case. The law is right on. And this is a case where in the lower court, the defendants asserted counterclaims against plaintiff who had asserted the breach of contract claims. And those claims were before the lower judge. The lower judge was aware that defendants were arguing and asserting and supporting with factual references, factual allegations, and documents that the plaintiff had breached his, materially breached his
fiduciary and contractual obligations prior to his termination.
So right there, if I may, I'm sorry, Judge Milky. You said that you had supported those counterclaims with factual material, and you allude to some discovery material in your brief on appeal. But so far as I could tell, that factual material was not made part of the summary judgment record presented to the judge in opposition to the motion for summary judgment.
Your Honor, and I wasn't the counsel at the time, so I sort of looked at this case probably similarly to how the panel is. I had to go back and go through the documents as well. But the counterclaims are in a pleading.
The counterclaims are, but the point is that if, to the extent that there are claims that are not supported by evidence, then at the summary judgment stage, you can't rely simply on the unsupported allegations of the pleadings. If there is evidence, it's incumbent on you to present that evidence in order to defeat summary judgment.
And Your Honor, I think the standard there is that applies when the plaintiff has affirmatively established that there is no triable issue of fact. I don't think, and I think the plaintiff cites and I'll say this in plaintiff's defense, we all sort of do this. We cite and say you have to come forward with material facts in a fashion to counter the plaintiff's assertion, but it's not. The plaintiff needs to establish affirmatively in this case, because it was plaintiff's claims, plaintiff needed to support affirmatively and establish that there was no triable issue, that there was nothing left out there that would go to the jury. And it's undisputed that the plaintiff failed to establish that, because the very facts and circumstances and allegations that would make moot the plaintiff's breach of contract went to the jury, because the judge recognized that those were material issues of fact. Those were part of the discovery record at the time. Those actually were before the court in the counterclaims alleged, the pleadings before the court. And furthermore, they had been before the court dating all the way back to within a few months of when the first original complaint was filed. And
Counsel, could I just stop you? I have a related question, which is the summary judgment judge presumably could have looked and seen that there were outstanding counterclaims out there. My question is, to what extent did your client highlight the linkage between those and the underlying claim? Were there specific arguments at the summary judgment stage along the lines of your client was justified in not paying the money because of a corresponding material breach by the other side?
Yes, I think there were. I think if you look at the summary judgment transcript of the hearing, that hearing shows that the judge recognized, they use the word misdeeds, but if you look at the transcript hearing, the judge recognized that those misdeeds were allegations, and plaintiff's counsel actually summed it up by saying, these are allegations of financial misdealings and conduct prior to termination, because obviously Mr. Vignani was no longer working there.
No, but you could see it as a set-off as opposed to a defense, if you understand the distinction I'm making.
Your Honor, I would say that in Pruszynski, and if you look at footnote 8, I won't read it to you, but I believe it's footnote 8 in the Pruszynski case, the court points out that the issue isn't that the court is coming up with this additional condition and using that condition and inserting it into the contract and saying, here's a condition of the contract that wasn't met by the plaintiff in Pruszynski, and therefore the plaintiff breached. The court is pointing out that it's a part of every contract. It's a failure of performance. It's a legal determination. You look at whether or not the plaintiff has come forth, and if you look at what the plaintiff's obligation is on summary judgment, it's to say, I've met all the criteria. Here are the facts. Here are all the relevant issues. Here are all the criteria for a breach of contract, and I've met those. One of those criteria is I, as the plaintiff, met all my obligations under the under the contract with this employer. I met all my obligations, and it is enforceable at the time of my breach, at the time of the defendant's alleged breach. The plaintiff did not do that here. The plaintiff put all of those issues in a box and said, and the court ultimately did too, well, we'll handle that later. We'll decide what effect, if any.
No, but it sounds like your client went along with that at the time.
I don't think that's true, Your Honor. I think that, I think what the counsel at the time did was point out that the contract was ambiguous, raised the issues of the misdeeds of Vignani, which were already set forth in the counterclaims, and the court acknowledges that it's aware at that point there are these counterclaims. And if you look at the counterclaims as stated and the underlying issues that were raised, I would say in the summary judgment hearing, if you're asking me if counsel at that time went through each counterclaim and read those to the judge and said, we have facts to support these, and here they are, I don't think that was done. I mean, I think the record speaks for itself, but I don't think that changes the fact that prior to defendant even coming forward and defending against the summary judgment, it was plaintiff's obligation to go through those potential issues and show the court that there was no disputed material issue of fact, and let the court apply the law to the state of facts as they were. And the state
Let me try coming at that a somewhat different way. You've also seen the argument in the plaintiff's brief that in any event, the question of breach was put to the jury precisely framed by those counterclaims. Whether, in other words, the defendant was excused from performance by the plaintiff's misdeeds. The jury rejected those claims. Why doesn't that foreclose the argument that you're now making?
Because the jury rejected those claims after the jury was told by the judge that the judge found in favor of the plaintiffs. The judge found in favor of the plaintiff's breach of contract claim. The judge
but the specific question of was there a breach was put to the jury as well.
That it was, so I should clarify. That was put to the jury, and I think plaintiff also makes an argument that somehow because of the question, the way it was phrased to the jury, there was a waiver by defendants. Defendants continuously objected to the law of the case being that there was a accepted liability on a breach of a contract claim by plaintiffs. That was objected to throughout. So so if you envision the court telling the jury at the beginning of the trial, here's the situation. I've already found in favor. The court has found in favor of plaintiff's breach of contract claims. The court has found that and implicitly in finding that, the court had to find that the agreement was enforceable by the plaintiff at the time of the termination, which would mean that the counterclaims were moot going into the trial, essentially, even though they were allowed to exist.
Well, no, but I don't understand that, because if they were put to the jury on a full factual record and the jury rejected them, are you saying that entire exercise was illusory?
I think it was somewhat, and here's why. I think the parties, the defendants should have been able to go into the trial on an equal footing with plaintiff as to at least the liability. Now, if the judge wanted to interpret the contract and say we have a contract that requires defendants upon termination to pay severance, then that's one issue. But the judge said there was no prior breach, because if there had been a prior breach, then the judge would have had to rule consistently with Przezinski. And I should add, I'm sorry, go ahead, Your Honor.
No, Przezinski, in my view, stood differently on appeal and on the summary judgment record, because there was factual material that was presented in the summary judgment itself. And so the panel that saw the case on review was able to identify the specific facts. Here, I went through the papers on summary judgment. There was no, the argument that was made was that the contract was ambiguous. It was no longer in effect. It doesn't apply here. The argument was not made that there was an affirmative defense to the performance of the contract.
But I can't disagree with that. I've read the transcript as well, and I've seen the opposition that was filed. So certainly I can't disagree with that, as you stated. But I think the issue of the counterclaims and defendants' allegations, which are certainly supported in the record, as the judge found when plaintiffs moved
in the record at trial, not on the record at summary judgments.
Well, Your Honor, at the time of the summary judgment, I guess a year earlier, the defendants had filed the counterclaims. And
but the argument wasn't made, the evidence wasn't presented, and yet you're suggesting that it was error for the judge to enter summary judgment on the sole claims that were argued, the sole theories that were argued at summary judgments. Enter an order resolving those questions so that they would not, as a matter of law, so they wouldn't be put to the jury.
And I can only reiterate that because the counterclaims were there, I believe that's accurate, Your Honor. I think allowing the defendants to move forward on the counterclaims does not put the defendants on a fair footing at the time of the trial because there's already been a determination of breach. If there's already a breach, that already suggests to the jury that the plaintiffs complied with all the required performance.
No, not at all. It means that they that whatever issues there were did not void the contract, but they may be separately actionable for independent damages.
Well, Your Honor,
they could be severable claims.
I'm sorry.
They could be severable from the question of the enforceability of the contract. In other words, they could be affirmative counterclaims that do not absolve the defendant of performance of its obligations under the contract. That's a separate theory that was not presented at the argument. It was not an affirmative defense. It was a separate counterclaim.
I think, Your Honor, I think what you're saying is a legal, in the abstract, might be accurate. I assume it is, but what I'm saying is the nature of the allegations and the nature of the evidence supporting those allegations clearly, and as stated, there was an allegation of breach of fiduciary duty by Mr. Vignani. And if you look at the nature of those, I ultimately put them in my reply brief, and I would ask the court to look at those. That was the state of affairs at the time of the summary judgment. Now, if you're saying the defendant didn't do a good job of putting that state of affairs in front of the court, again, all I can say is I read the same transcript. What I'm saying is the court clearly was aware of the situation and aware of those counterclaims. And if you just simply read the counterclaims themselves, they establish that there is a material breach. If there's a material breach, the defendant's position at the time was there was a material breach, then that material breach would render moot the defendant's obligation to continue to perform under that contract.
You know, if I'm putting myself back into my trial judge days and thinking, really, I have to invent a theory that was never presented to me.
Your Honor, I wasn't part of the case at the time, and
well, I understand nobody's blaming you. It's just a question of what the effect is for your client.
Well, what I would say is the judge, on that note, Your Honor, the judge did actually do that in his ruling. He found that both DeLeo and Mass Medical were employers. There was no evidence at all that DeLeo was Vignani's employer. And in this case, what we're talking about is DeLeo personally liable? So how we got from if you look at the plaintiff's brief as files, doesn't even allege that they're both employers. And I would say, you know, I see my time's expired.
You may continue, finish your sentence, and then we'll go on.
Okay. And I would say on the issue of that, the personal liability, that wasn't before the court. And I think that goes to the same issue that I'm addressing here.
Right. Thank you very much. Attorney Callahan.
Thank you, Your Honor. May it please the court. An important distinction between this case and the Prosinski case is that the motion, the summary judgment motion brought by the plaintiff was a partial motion for summary judgment on counts 1 and 2 of the complaint, which was plaintiff's allegation of breach against DeLeo, the individual defendant, and Mass Medical Services, the corporate defendant. There was no, that issue presented a clear question of law as to whether or not the one-page document signed by both men on 2 occasions was an enforceable agreement. That is a question for the court as to whether or not the clear and unambiguous terms of that agreement accurately reflect a meeting of the minds of the two individuals involved and the company involved. The court interpreted the agreement and did so correctly because the court reviewed the entire document and reviewed it under its plain and ordinary meaning of the words in the document. And the document plainly sets out an employment for Mr. Vignani and certain terms of his employment. The language, although maybe not exquisite, sets out different exit scenarios if Mr. Vignani's employment ended. Breach of contract is typically an issue for the jury, but here there were no issues of material fact in dispute that Mr. DeLeo terminated Mr. Vignani, and he confirmed that first happened on a telephone call. It was then confirmed with an email, and it was also undisputed that there was no severance paid. So reading the agreement, the court correctly found that paragraph 6 applied. So that the court's decision, and that didn't dispose of the entire case, which was the scenario in Prosinski. All that decided was plaintiff's breach of contract claims. That didn't decide what, if any, damages would be awarded for that breach or any of the counterclaims. And the court is correct. The opposition to the summary judgment motion made no argument that there was a pre-existing breach. The argument for the entire case from day one was that the document was a guideline, not an enforceable contract. And if it wasn't a guide, leaving aside the fact that there is no exception to contract law for what people subsequently consider guidelines. The second argument was that the language was ambiguous and therefore we needed fact finders to decide what paragraph applied or what the words meant. The court decided that the language was unambiguous. That is a decision for the court. It was still up to the jury on damages, and the jury heard evidence about damages and awarded damages. As to the counterclaims, the court is correct. At the moment of the summary judgment hearing, there were counterclaims. There was no evidence submitted to support any of those counterclaims. So there was simply allegations, and the allegations are in the form of counterclaims, not a defense to the contract of pre-existing breach, but separate claims of breach of contract and separate claims of breach of fiduciary duty. There was no evidence to support either of those claims. The counterclaims, if the court reads them, paragraphs 31 to 41 of the counterclaim relies on an extensive accounting audit / review that Mass Medical did after Mr. Vignani's termination that revealed misdeeds by Mr. Vignani, and that Mr. DeLeo was unaware of any of those misdeeds until this accounting audit review was performed. Again, that is not evidence of a pre-existing breach because the counterclaim alleged that it was all based on an audit that was done after the fact, and then Mr. DeLeo wasn't aware of it until after the fact.
Although, counsel, that doesn't mean that the breach didn't happen before Vignani was terminated. So that argument seems a little thin.
Well,
the fact that he discovered the breach after doesn't mean it didn't happen before.
True, but again, there was never any evidence submitted supporting any breaches.
So this case would be a lot different if the defendant had come forward with, at summary judgment stage, with a argument that said, yeah, there was an employment contract, but it was materially breached by the plaintiff before I fired him.
Right, that's correct.
Or even without conceding, yeah, there was an employment contract, but saying there wasn't an employment contract, it was ambiguous, it really was only guidelines. But even if you disagree with that, even if you find that there was a material breach and therefore it's unenforceable by virtue of the plaintiff's own misconduct.
Right, but the opposition was, it's a guideline, it's not an enforceable contract. And if it's an enforceable contract, it's ambiguous. So the court can't tell us what it means. We need the jury to tell us what it means. The court ultimately, as this court noted, the court ultimately put the question of breach to the jury, the Vignani's breach, And again, the summary judgment decision was a partial summary judgment decision. It was susceptible to the court's further review based on a fuller record. And if this court wishes to, there were several points during the trial where the court reconsidered its summary judgment decision. There were several points where the defendants sought to amend their counterclaims, but in the charge conference, which is in the second volume of the record appendix from page 705 to 750, there was a discussion about whether or not there was a contract and whether or not the summary judgment decision was correct or should be revisited. And then that charge conference picked up on the Monday following the Friday on record appendix volume 2, page 725 to 749. And the court ultimately put the question of breach, Vignani's breach, to the jury on the issue of whether or not, since the evidence had been that Mr. Vignani was in charge of the finances, whether compensation had in fact been equal for both men, which is a feature of paragraph 2 of the agreement. The agreement does not include performance standards or revenue metrics. The agreement itself identifies that Mr. Vignani will be hired, compensation will be equal, Mr. Vignani will have the opportunity or have the option to acquire equity in the company, and then provides for various exit scenarios. So defendants repeatedly asked to put the breach question, but the court for most of that colloquy, and I invite you to read it, was troubled that having now heard all of the evidence at trial, there was no evidence to support any breach. The ultimate breach question that went was based on paragraph 2 about compensation being equal. The jury considered that, the jury rejected that. So what the court's handling of the summary judgment was entirely appropriate and correct. The court heard all of the evidence, considered reconsidering its summary judgment several times throughout the trial, and ultimately did not, because it was satisfied after hearing all of the trial evidence that the document was clear and unambiguous, and it created a severance obligation. And again, it's never been contested that no severance was paid or that DeLeo terminated Vignani. As to
why does it matter that the judge reevaluated the question on the strength of all of the evidence at trial? If there were to be a reconsideration at trial, wouldn't the resolution of those factual questions be for the jury?
They were. Well, as to what the basis of the breach would be?
Yeah, I mean, to the extent that the breach was solely, the breach question put before the jury was solely based on the equal compensation, then your brother may be entirely correct that the judge never put this question of whether the plaintiff's misdeeds absolved the defendant from performance of the severance portion of the contract.
Well, my understanding as to the reason why the judge put the breach question was because he was weighing the evidence he just heard with the argument, and the only basis he found was as to whether compensation would be equal on breach of contract. There was also an allegation of breach of fiduciary duty, which was given to the jury, which the jury rejected, which was based on the alleged misdeeds.
Right, and it's. I think there's a separate question in my mind about whether the jury's rejection of the premise that there was a breach of fiduciary obligation may negate any actionable error, even if there was something at the summary judgment stage. But that's a different question.
Right.
Putting aside the potential issues of waiver, what is the theory? What is your theory on how the individual defendant is personally liable?
The plain and ordinary language in the agreement itself. It's entitled Employment Agreement between Michael DeLeo and Anthony Vignani. When it was signed, Mr. DeLeo was the sole owner of the equity of the company. The agreement provides the ability for Vignani to acquire equity in the company. Nobody other than DeLeo could have provided him that. DeLeo himself signs it on 2 separate occasions, makes no distinction between himself and the company. So on the plain and ordinary terms of the agreement, Mr. DeLeo is liable under the agreement just as Mass Medical. And that was an issue that never came up at summary judgment or throughout the trial. And I know you said not to address waiver, but the question that was put to the jury as to breach both for Vignani and for defendants was and or. It was always DeLeo, Mass Medical, and on the other side it was Vignani. So that's why in my papers I described the question as joint and several liability. I don't mean to say that that's the only reason DeLeo would be liable. It's the only way I can think to describe a question that says DeLeo and or Mass Medical. The jury didn't have the option to parse between the two. And I think that's correct because the evidence didn't support it. I mean, if you look at the agreement is an agreement between DeLeo and Vignani, signed by DeLeo twice. The plain and ordinary meaning or interpreting the words on the page from their plain and ordinary meaning.
Or the words on the napkin.
Originally napkin and then a one-page document. And that's record, the first volume, page 130 of the record appendix is the one-page agreement that the two men without lawyers, the testimony from Mr. Vignani was that they spoke about it, then he typed it up, then they signed it. They signed it on 2 occasions. And importantly, they followed it to a T. There was evidence that the jury heard about how each year, once they got to 2005, the company issued K-1 forms to Mr. Vignani as a shareholder. And from that point forward, in addition to the K-1 distributions, they took efforts to true up their compensation so that the compensation would be equal to paragraph 2. Everything that was done was consistent with that agreement.
Just so that I'm clear, you said a couple of times that Mr. DeLeo signed the agreement twice. What you mean by that is that he signed it when it was originally entered into, and then both parties signed it again in March of 2005.
Correct.
Okay.
Correct.
So it's not as though he signed in 2 separate places when he originally executed.
Correct. Both men signed twice.
Yeah.
And with regard to Mr. DeLeo, he did not distinguish in what capacity he was
signing. I understand.
And in fact, the contract, such as it is, refers to Mass Medical as the company, whereas it seems to refer to DeLeo and your client as the parties. So it seems to, its natural meaning would be that it is actually an individual, individually enforceable against DeLeo because he is one of the parties.
Right. Right. And that issue is raised for the first time on appeal. It never came up at summary judgment. It never came up during the trial. It's obviously coming up now. And DeLeo is the only remaining defendant with regard to this appeal. The only last thing I would add is that there's also an argument in the brief that Mr. DeLeo wasn't personally served. That's an issue that was never, has been waived by a complete failure to raise that at any point, especially with in any of the affirmative defenses that were asserted in response to the amended complaint. But unless there are any other questions, that's all I had to add.
Seeing none, I will thank you both. That concludes the argument in this case and concludes our argument session. I want to thank our sessions clerks who helped us survive the inevitable glitches of the technology platform, most of them at the end of my internet connection. I will address that separately, but thank you all, and we are in recess.